afternoon. This is Raymond De Leon with Smoothoperationoflaw, and today we are going to talk about Title 42, Section 1983, which is a deprivation of rights under color of law. Hopefully, by the end of this discussion that I am having on this vlog, you will be able to understand the specific elements of what you need in order to make a claim. Please be sure to like, share, and subscribe, okay? We're getting this truth out there so that people can stop having disputes that are unfounded. I'm trying to express this idea so that people can get a focal point on what elements they need in order to claim that their rights have been violated. This is not legal advice. Please be sure to take full liability of anything that you choose to do, because I am not telling you what to do. I am only expressing what is evident. What you're going to see on the screen today is an actual case where Title 42, Section 1983 was successful. In a nutshell, I am going to tell you what you are going to be told. What you are going to be told is that this guy, Robert Mitchell, was sitting passenger in a vehicle in which he was arrested in California for not producing any ID. He won a $15,000 settlement for being detained unlawfully as a result. The police department was also ordered to have a training on what not to do when they have encounters with the public. So this guy, Robert Mitchell, okay, is driving in a vehicle in Bakersfield with 3 other black people in his vehicle. This is not a race thing. I am only telling you what is on the document of the complaint. Okay? Robert Mitchell, a black man, highlighted. Mr. Mitchell was passenger in a vehicle with 3 other black people when a Bakersfield police officer pulled the vehicle over purportedly for a trivial traffic violation. Now, here's the deal. Okay? The police can pull you over. Period. That's a detainment. Check Terry versus Ohio. The problem is that in the state of California, when you are a passenger in a vehicle, since the state is not a stop and identify state, nor was the party, Robert Mitchell, a operator of that vehicle, he didn't have any obligation under any penal statutory code to produce ID when requested. He wasn't in commission of committing a crime, nor was he suspected of a crime. His only purported crime was that the motherfucker was passenger in a vehicle and did not want to produce any ID or answer any fucking questions. Period. So the police hassled him. They said, hey, we need your ID. No, you look suspicious. Whatever they say. Okay? I'm making it up, but just to give context to the situation. Okay? Ultimately, Robert did not want to give his ID. The police officers took offense. They ended up arresting him. Okay? And he also invoked his constitutional rights to not answer any of their questions during the course of pretextual traffic stop and the ensuing unreasonably lengthy detention. No criminal charges were filed against him. Okay, but the officers handcuffed him and forced him into the back of the patrol car and separated him from his family to spend 12 hours in jail, all because he asserted his constitutional rights. He was seeking damages for violations under the First and Fourth Amendments of the Constitution and the California Constitution and state law. So here's the identification of the parties. Okay? He made his claim, meaning Mitchell, made his claim pursuant to the California Tort Claims Act. Okay? There's the code, first sentence. Excuse me, let me highlight it. Okay? And the party who arrested him was part of the city, an employer. Was part of the city. That means they were a sheriff or they were an officer, which in this case, they were sheriff. Well, let me see. Let me make sure of that. Oh, no, excuse me. It was just the police department. Sorry about that. All right. So, because the officer was acting in their official capacity and they were asserting an obligation on the parties, on the plaintiffs, which is Robert, an obligation they were asserting that he had no obligation under any law to comply with. The police officers, who are law enforcement, were no longer enforcing a law, making the detention unlawful. Jurisdiction and venue. The court has subject matter jurisdiction over Mr. Mitchell's claims under the Constitution of the United States, right? So the U.S. Constitution, 42 U.S.C. 1983, which is a deprivation of rights under color of law, 28 U.S.C. Section 1331, which is a federal question because they are questioning if there was any law that was applicable under any state statutory law, federal statutory law, or constitutional provision that allow for those officers to demand an unlawful act from Mr. Mitchell. And then they had 28 U.S.C. Section 1343, which is civil rights. The court has supplemental jurisdiction over the plaintiff's state law claims under 28 U.S.C. Section 1367. Now, let me explain to you what 28 U.S.C. Section 1367 is. Supplemental law means that you are going to check the state law that Mr. Mitchell violated. And because they are going to look at state law, which there is none, well, then I guess in this federal jurisdiction, because this was a federal filing in the United States District Court for the Eastern District of California, okay, they're going to look at the fact that there is no supplemental law from the state, and they are going to apply that federal statute to the states, being that the states are part of the Union and must respect the United States Constitution. The venue is proper in this district under 28 U.S.C. Section 1391 because the acts and omissions at issue in this lawsuit occurred within the district. So, since it's in the Eastern District of California, Bakersfield being, the district court is the proper venue to apply the federal provisions afforded to the citizen, okay, against those officers. Intra-district venue is proper because the action arises out of Kern County. On the 20th of July, 2017, Mr. Mitchell timely filed an administrative tort claims with Bakersfield. Sorry about that. With Bakersfield. Okay? The city issued a notice rejecting his claims. Mr. Mitchell has exhausted all available administrative remedies. So the state did not want to waive immunity for their officers' actions. Okay? The officer was not law enforcement, wasn't enforcing the law, and the state refused to compensate Mr. Mitchell. On March 17, 2017, Bakersfield Police Department officers stopped the car for the purported purpose of enforcing the vehicle code for the stated reason that they saw air fresheners hanging from the car's rear view mirror. The tires were bald, and the car came to a rest in the turn lane with its wheels touching the dividing line. So now they're going to try to validate the purpose of why they stopped Mr. Mitchell. Remember that I said Mr. Mitchell was not the driver. So the conversation should have only been with the driver. The tires, the freshener is not Mr. Mitchell's problem. So it does not allow those police officers to use it as a pretext for reasonable suspicion. Only the operator can have liability for any of that. With that being said, it goes on about the context of what happened, threatening Mr. Mitchell. And now let's go to the claims for relief. First claim for relief, Fourth Amendment, right? So what's Fourth Amendment? The Fourth Amendment is search and seizure. So the foregoing allegations are, realleged and incorporated herein. Realleged, and incorporated therein. I don't know why I can't read right now. Defendants violated Mr. Mitchell's Fourth Amendment rights by subjecting him to an unreasonable seizure in the car. They unreasonably seized and detained Mr. Mitchell without reason to suspect he was involved in a crime and escalated his detention beyond the permissible scope of an investigatory stop without probable cause. Defendants also violated Mr. Mitchell's Fourth Amendment rights by arresting him and causing him to be jailed without a warrant or probable cause to support his arrest. They relied on an invalid basis, Mr. Mitchell's initial refusal to answer questions about his identity, to arrest him for violation under California Penal Code Section 148A1. What is 148A1? It's a false report made by a cop. Defendant Sherman directed, approved, and authorized Mr. Mitchell's unconstitutional arrest. He knowingly failed to provide defendants with from violating Mr. Mitchell's Fourth Amendment rights. His audible admonition to Mr. Mitchell to give his information to the officers or go to jail, and his directions to the defendants caused Mr. Mitchell's unlawful arrest. And he knowingly disregarded the fact that Mr. Mitchell's arrest and subsequent incarceration would be the obvious consequence of his actions and omissions. Okay? So here's the bottom line. Second relief, the First Amendment. He had a right to speak, okay? He was verbally expressing his disagreement with them about their interpretations of laws and facts, including whether he had a right to remain silent in the face of their questions. So we already know how this went down. Hey, man, I don't have to talk to you. Why the fuck are you bothering me? Blah, blah, blah. You know what? Fuck you. This is illegal. The cops are like, shut your mouth. Shut your mouth. Shut your mouth. I'm giving you an order to shut your mouth. First Amendment. He doesn't have to shut up. He can talk all day. The third claim for relief is the false arrest, false imprisonment, and violation of California Constitution, Article 1, Section 13. And that's where the tort claim comes in. Okay? Subjecting him to a false arrest and imprisonment and unreasonable search and seizure. Okay? The Bain Act of the California Tort Claims. The defendants interfered with Mr. Mitchell's exercise and enjoyment of his rights under the United States Constitution and California Constitution. Mr. Mitchell's rights under the Fourth Amendment and Article 1, Section 10 and 13 of the California Constitution to be free from unreasonably invasive or prolonged investigatory detention in the absence of reasonable cause. Okay? He tried to remain silent which is the Fifth Amendment, and the the equivalent in the California State Constitution for that would be Article 1, Section 15 of the California Constitution. Okay? He wanted to exercise his right to shut up about any questions they're investigating about, but he used his First Amendment right to freely disagree with them. And that led to the jailing being a retaliatory act against him for invoking that right. And I'm going to keep moving. The prayer for relief is award him compensatory and punitive damages against all the defendants, award compensatory damages against the city, and award prejudgment interest on any award of damages permitted by law. Award the reasonable attorney's fees and other applicable law, and grant such relief as the court may deem appropriate. Okay, so now here's the training bulletin. Demanding identification. They had to learn that they cannot require some articulable reason to be lawful just because it's their belief. It is a general rule that any peace officer may approach and contact any person in public or anywhere else the officer has a legal right to be and engage the person in conversation. No probable cause or even a reasonable suspicion is needed for that. The law does not prohibit an officer from being able to try to engage in an uncoerced freaking conversation. So the law enforcement officers do not violate the fourth by merely approaching the individual in the street. But the person contacted is free to leave and need not to respond to the officer's inquiries. In such circumstances, a person need not identify himself nor even talk to a police officer. Even during a lawful detention, members of the public are under no duty to answer questions. Answers may not be compelled, and refusal to answer furnishes no basis for arrest. A passenger in a lawfully stopped vehicle may be asked for his identification. The Fourth Amendment is not implicated by asking for it, so long as the detention is not unnecessarily prolonged in the process. The only issue left hanging is whether a detained suspect must properly identify himself or be subject to arrest for refusing to do so. So the court seemed to hint, however, that he cannot be. However, the United States Supreme Court ruled that a person who is lawfully detained may be charged with a criminal violation for refusing to identify themselves. Such an identification requirement violates neither the Fourth nor Fifth of self-incrimination rights. Terry versus Ohio permit a state to require a suspect to disclose his name. Note, however, that the court conceded that a case may arise where there is substantial allegation that furnishing identity at the time of the stop would have given such police a link in the chain of evidence needed to convict the individual of a separate offense, thus implicating the Fifth Amendment right against self-incrimination. Some states have a specific statute making it a misdemeanor to refuse oneself when lawfully detained in a non-vehicular situation. California does not have such a specific statute. Okay, so conviction for an arrestee who refused to identify himself during the booking process, where giving a false name when arrested for shoplifting was held to be in a violation of PC Section 148. It still follows, however, that a person who is subject to police contact or lawful detention is not required to identify himself. Why do I show this? I show this because, hold on. Okay. I show this because there is how do I say, no reason in California to have to identify yourself. In a lot of other states, if you check your local state law, you could just put it into Google if you want, stop and identify states. And it'll show you how many states where you actually have to identify yourself. Other states where if detained, you must identify yourself. And then it will also show you which states you can walk around like it's California where you don't have to identify yourself. The mere principle that I am speaking of here is that a deprivation of rights under color law only applies to when there is a constitutional provision or some sort of federal statutory provision that allows for a citizen to have some sort of right guaranteed to him enforced. You do not get to just make shit up. You do not get to just say, well, I don't like the way the officer was talking to me, and so on and so forth, and fuck that, and I'm a man on the land, and you just make it up where the officers have no ability to enforce law on you. That is not how this works. There must be an error or omission. There must be some form of negligence, like the police neglected to observe the defendant's rights where he applied his fifth, used his first, and actually, was subjected to a violation of his fourth. All because he didn't want to produce ID. So now, with that being said, that concludes, just, a discussion on when, or at least a discussion pursuant to an example of when Title 42, Section 1983 applies. There are a lot more areas where Title 42, Section 1983 does apply. There can be Brady violations. A prosecutor may try to hide exculpatory evidence in a situation. Or, let's say you used the trademark situation with your trust, as Smoothoperationoflaw does, and you shut down the course of action inside of the courtroom by holding the participants of that trademark violation pursuant to your name accountable in a separate action for the usage of said name or mark. And then, because your case is injuncted from any further pursuant, you decide to go in your own separate action outside of that trust's action for the trademark infringement. And after that trust has an adjudication on its trademark infringement action, you yourself choose to go to court because you got the documents expunged, the record expunged, and then go claim a false arrest. Can that happen? Yes, it can happen. How do I know? I know. So if you get this last little bit of what I just put out there, then you will understand why I'm talking about deprivation of rights under color law. You can inherit a benefit from your trust protecting its trademark, and that benefit is resulting. That concludes today's video. I hope you guys have an outstanding day, and I hope it wasn't too long, and I hope you guys don't have a fucking headache by the time I'm done every day, because it takes about a half hour. Bye-bye.